Hi, everyone. Harry here to talk about, boom, there it is. The Supreme Court grants cert to review the decision of the Colorado Supreme Court knocking Trump off the ballot on the ground of the 14th Amendment, Section 3, and his having engaged in an insurrection. All right. First things first. It was the very first time they could have done it. They just received the last brief about cert yesterday. This is Friday as we tape. And indeed, they have conferences on Friday. That was scheduled. But usually, whatever they decide to do on Friday is released the following Monday. Here, they didn't want to wait even the 3 days. So, people kind of lay in wait for it. And sure enough, Friday afternoon, here comes the paragraph. And so what's the paragraph say? First, they grant. And it says Trump versus, it could have said Trump and Republican committee, which, as you recall, perhaps also had done a petition asking the Supreme Court to take cert, had done it before Trump, and the response from the people who'd won below was what normally would have been, no, don't take it, we're happy. They actually said, no, take it, and go lightning fast, have it done by the whole thing by February. And now Trump comes in at the end, but they style the case Trump v. And that means probably this is all a little bit, special singular rules, but it means probably they've taken his question presented. What's his question presented? Simply, Colorado got it wrong. It's just a paragraph that says, was there any reason that they got it wrong? So it encompasses every possible argument. And he himself has forwarded, I think, 7, if you count a couple pretty flagrantly state law arguments, but 5 anyway. And so now they'll have the parties will have to write up the petition on the merits, saying, who should win and who should lose. And they'll have to cover the bases of everything that Trump has raised, it seems to me, even though a few of them are very low probability that the court would look at them. So that's point 1. And sort of point 1B, an incredibly fast schedule. Supreme Court in normal times, something will take maybe a year and a half. Even in normal expedited times, it'll take a couple months, say. They're going to hear oral argument in a month or 34 days. It's on February 8th, Thursday, in about a month. And so they've ordered Trump to produce his brief. They're giving him these extra 3 days, basically. He's got 13 days to do a brief on the merits. And presumably that same thing applies to the Republican Party, though they're not named. They probably will, and the court can still, say no, thank you, or sure, come on in. In a way, it doesn't really matter. They'll also get amicus briefs here anyway, and then 10 short days for the winners below, the ones that Colorado Supreme Court ruled in favor of, to respond on the merits. Again, which is to say how the court should rule, not whether it should take it. We are now on the merits, and then I think 5 days until February 5th for Trump to do a final reply on the merits, and oral argument on the 8th of February. And that's sort of point 1C here. Even when they're going super fast, they'll typically slot a case into the soonest already established calendar. But here they're even jumping that. So it's not just February, but before other February cases. So it will stand alone. They do this. They did it in Nixon, say, and in Bush v. Gore. But they'll be doing it here. So just February 8th will be this case. Second main point, kind of however you slice it, it's hard to even think of, and I've tried a sort of precedent here. On the one hand, it's momentous and casts a shadow over an entire election in a way that's happened in a handful or fewer times in the Supreme Court's history. That's not a happy thing for the Supreme Court. Bush v. Gore is, to many people's lights, the low point of the since Dred Scott, the low point in the last 100 years for the court. But they saw themselves as forced and came in and basically commandeered the election result. Arguably, they've had, Nixon was super important in this way. But at least in both of those cases, there was law out there. Bush v. Gore is a little bit funny because Rehnquist, then the Chief Justice, sort of made some stuff up to make it just for this case. And they said kind of shamefully in Bush v. Gore, what we're saying is only for this case, no precedent, which is, if you think about it, the kind of antithesis of what a court is supposed to do. But anyway, we have those kinds of stakes here, but basically no law at all. There's there's some very sparse 19th century law that might figure in by a Supreme Court justice who was sitting at the Court of Appeals level. Griffin's case, you may be hearing about in coming weeks, but they are really writing on a blank slate. And sort of third point, it's not just a blank slate, but it's a very different slate from I think, the constitutional slate, even though they're interpreting the Constitution. And what I mean by that is when the Constitution was written, and even the 14th Amendment written, the framers in particular, 18th century, they didn't have in mind, the big surprise turns out to be the two-party system. And they imagined, I think, factions. And if you think about that for a moment, I think you can see that it makes it less a matter of sort of heartburn that there be a patchwork solution here where it matters different for somebody's on the ballot in some states but not others. Not today. I mean, it just feels to me very strongly like, notwithstanding the kind of arcane process of the Electoral College, it's just a cultural and political fact that this is a national election. And to have a national election where one of the two parties is not on the ballot in some of the states, but in the rest he is, that strikes me as, it's not unconstitutional, I think, but it is ugly, it is funky. I think it will probably be anathema to the Supreme Court. Now, that bears some more thinking about, because we're talking about what is the least sort of ungainly or consequential action the court could take. They are certainly not going to want to go down in history as having decided this election and usurped the will of the people. So what way does that cut in terms of their possible ways of deciding the case? We'll be talking about this a lot in the coming weeks. But whether or not it sort of pushes them from the get-go to a solution that is uniform and doesn't permit this patchwork pattern where Trump is off in some states but not others, that is a really big threshold question. Because if they do feel that way, I think it really cabins both their means of deciding the case and the bottom line as well. So that's going to be big. There are, in the hour or so since things were granted, there are the usual suspects, including me, out there on the airwaves, and they're saying very different things. And I think it really comes down to differing assumptions about whether the Supreme Court will find it really repellent or, very much in its job description to keep from happening a kind of patchwork solution. I think that really figures in deeply for how they go about things. Final sort of point to make in terms of how they go about things. This may well be a case where they decide on the outcome that matters most, and that they can get the biggest consensus, the Chief Justice can, and so it looks the least like the sort of polarized, Bush v. Gore was the ultra polarized 5-4 result. Here, a 6-3 result along party lines would be really pretty disastrous for the court. So there's going to be a lot of talk in coming weeks about politics, but I think it'll be in a crass way of, the 6 Republican appointees or the 3 Trump appointees wanting Trump or not. I think the politics here, if you even want to call it that, are different and broader and appropriate. That is to say, I think the court will be thinking hard about what's the right result for the nation, and they might be thinking about that first before figuring out just how they want to go. That's a kind of result orientation, right? That's a kind of political way of looking at things, but it's not a crass low politics, I want Trump or I want Trump out of there. So the court's sense, the individual justices' sense, and the court as a whole sense of the role of the court and their own sense of how to keep the court in its proper lane in the decision over election, that is really going to be uppermost in their minds. So quite a rock and sock and ride we have ahead, and then I think we can expect, we'll know better when the 8th comes, but I think we can expect a decision very soon, very possibly before March 5th, Super Tuesday, which is a date when the die begins to be cast for who the Republican nominee is. And, the case just inevitably, unavoidably, and to the Supreme Court's chagrin, is so braided up with the political system, and the political system in a presidential election year with a candidate who, and the electorate about as polarized as ever, and with a candidate who really does threaten to bring an end to the Democratic experiment. Stakes could not be higher. This is one for the ages, no matter how you slice it. And we'll be slicing it and dicing it and talking quite a bit more about it in the coming weeks. But for now, the big news is in. Boom, there it is. The Supreme Court takes the case, and we'll have oral argument on it February 8th, in barely over a month. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.